denied as non-existent. My lords, with regard to fair labelling, if I may go to my table of statutes, because their essential argument and Justice Harishankar's argument at its highest essentially says that the legislature, perhaps having wished away the idea that rape in the context of marriage is not rape, has otherwise provided for the prosecution of the offence under other sections. So let us look at the primary section that they cite, which is the erstwhile 498A and the current section 85. The husband or relative of a husband of a woman subjecting her to cruelty. Whoever, being the husband or the relative of the husband of a woman, subjects such woman to cruelty shall be punished with imprisonment for a term which may extend to 3 years and shall also be liable to fine. So what they've done is that they've split up for 498A, and the second part is in 86 BNS, otherwise it's been wholly retained. Here they define cruelty. Cruelty is not rape. Cruelty, for the purposes of section 85, cruelty means any willful conduct which is of such a nature as is likely to drive the woman to commit suicide or to cause grave injury or danger to life, limb, or health, whether mental or physical. Where is it? I beg your pardon. Her or any person related to her to meet any unlawful demand for any property or valuable security, or is account of failure by her or any person related her to meet such demand. So the second part is related to dowry. And if you are raping someone in relation to dowry, then that might kick in. The first part is in relation to rape, but only that rape that will drive her to suicide. So if that rape doesn't drive her to suicide, or is of other such extreme cruelty, then it's not covered by 498A. Now similarly, old section 323, if there is simple hurt, then it does not cover what are the actual ingredients of rape, which is penetrative intercourse against the person's will or consent. So therefore, the concomitant crimes are punishable. And the courts are acting in that regard. So when there is a rape that happens outside of the context of marriage, very frequently you will also have 498A. I beg your pardon, 323. Or you will have 326.
Exactly. Offences are punishable even within the fold of marriage.
Yes.
Take a case. The husband demands, wife declines. So we just envisage a situation.
Yes.
Husband goes to the extent of confining his wife in a room. That's wrongful confinement. Then he threatens her. That's administration of threats.
503, 506.
Criminal intimidation. Then he starts assaulting her. It could result in simple hurt. It could result in grievous hurt. At the end of it, the lady succumbs. Correct? The act is completed. So 323, 324, 325, 326, as the case may be, prima facie committed. Wrongful confinement, 352, I don't know about BNS, committed. Criminal intimidation, committed. All this being committed for what purpose? that the wife succumbs.
Yes.
But the last part of his act excludes him. It doesn't constitute an offense because he happens to be the husband. So perhaps your line of argument is that if these are the acts which constitutes an offense, even during the marital tie, be it husband, wife, then why this exception? Because he did all this because he wanted this. I'm just putting it in a simple language, not
That's exactly, that's
very
exactly
elaborate.
what my lords, yeah.
So that's what you want to convey.
My lords, if I may take that one step beyond the act of succumbing. If she says no and the intercourse happens, then all of the provisions my lord cited will apply, but 375 or section 63 of the BNS will not apply because he's the husband. Then if he kills her, that will apply.
This word no is something which will hear the other side also.
Yes.
We are at present envisaging a situation where the husband goes to this extent. He goes to this extent, assaulting his wife, behaving rudely. That would constitute everything, 498A, 323, 325, 326, if it results in grievous hurt. But when the final act is committed, you say you will be prosecuted for all these offenses, but you cannot be prosecuted for this. Now take a case where nothing of this happens. Husband says, I demand. Lady says, wife says, no. Then what?
That would be exempt under the exception, my lords.
Correct. So how do you perceive this no from the wife? When it comes to marital relationship, it is the husband who is demanding, wife is in no mood, is declining. She believes that my husband should not have done this. This is forcible act. How do you perceive that?
My lords, the impugned judgment.
And on the next day, she goes and lodges a FIR that this is what happened.
My lord, what is falling from my lord?
We want
That
your
no.
assistance. We want your assistance on this.
Feeds into the Article 19(1)(a) argument, which is that currently my right to say no takes away my right to also say a free and joyful yes. Because I have been reduced by this exception to a legal subject and a sexual object.
So your argument is that if it is no, the only option for the husband is to go for divorce.
My lords, he may go for divorce. He may wait till the next day. My lords, he may be more charming. He may talk to me. Do you have a headache? That's all. He may say, do you think you might change your mind? Or, my lords,